content, you'll not be dealing at this level, you'll be dealing in the final level. Okay, so Perissa one of the we're going to go for a bird's eye view only. Okay, so let me join. Let me continue. Please join with me. Directors. Before understanding the term director, let us try to understand. Let us try to understand who is an officer. Officer includes a director. Okay, please understand. Officer includes a director as well as any person under whose directions or instructions the board or any one or more of the directors are accustomed to act. So they say, and we act according to their directions or instructions. So we say that person as officer. How are you going to differentiate directors and board of directors? Directors are the human individuals, whereas if we talk about board of directors, the complete set, the collective body. So if you go for the definition as per the Companies Act, Clause 34, Section 2 defines director means a director appointed to the board of a company. It can be any person. There is no qualification at all mentioned. But disqualification need not be this type of a person. அப்படியே நான் mention பண்ணிருக்கலாம். Whereas if you go for board of directors or simply call it as board, in relation to a company means a collective body of the directors. Okay. So here directors are dealt in individual sense, here it is dealt in collective sense. Powers, no individual power unless specific authorization is given here exercises all powers except prescribed by the act in general meeting. Okay, so which means the Companies Act itself gives certain powers to the board. How they are selected? Here when we say directors, we are going to learn different types of directors. So for each and every case, it depends on how they have been selected. But whereas if you go for board of directors, you should go as per the act and the articles of association. For example, if we talk about private company, it says that minimum we need to have 2. In case it's a public company, it says minimum we need to have 3. Okay. So when it goes for the collective body, we have to follow the act and the articles of association. Whereas if we talk about the individual director, probably depending on my company's business, I can define my director's qualification and other things and all. Okay. Nature, yes, directors are the eyes, ears, brain, hands, nerves, and other essential limbs, we can say. But whereas if we talk about board of directors, it's the nucleus of the company. Because of this management only, we have the company running. And if you check section 149, it says only individuals as directors. That is what it means. No body corporate, association, or firm can be appointed as director of a company. There raises a question whether director is a servant. Please understand, director is not a servant of any master. He cannot be described as a servant also. Director is in fact a director, or we can be saying that he is controlling the affairs of the company. Whereas this special contract called as law of agency, very pukka it matches for the company and the management. So both principal and agent of the company is the company itself, and see, beautiful. Company is treated both as principal and agent, and director is the agent of the company. Is it okay? Director is the agent of the company. And directors and board of directors are what you call as the trustees, and they come as they come under fiduciary capacity. Position of director. Professional men are hired by the company to direct its affairs. Obviously, professional men, but they are not discussing anything about the professional qualification. Okay. Officers of the company, and they work as an employee in different capacity. Who can be a director? Promoters, relatives can be a director. Promoters, relatives of promoters can be a director. Co-promoters, or completely where they form as owners or something like that. They can be directors, or they will be called as promoter directors. Okay. Whereas if you talk about individuals, yes, individual outside need not be this type of an individual. The individual outside the company who is competent to manage can also be called as a director. Professionals also can be directors. Okay. ஒரு மெடிசன் கம்பெனி இருக்கு, ஃபார்மா கம்பெனி இருக்கு, அதுல எக்ஸ்பர்ட்ஸ், கெமிஸ்ட்ரி படிச்ச எக்ஸ்பர்ட்ஸ் or doctors can be directors, right? So they become professionals over there. Role of directors for efficient functioning. Yes, obviously they need to run the company. So we need to go for smooth and efficient functioning of the organization. So it depends on. And what do directors do? Okay, this is a colloquial the directors do, but it depends on. It formulates policy, it establishes organizational setup, it implements and helps to achieve the objectives of MOA. What are the objectives of MOA? Objects. Object plus portfolio. So those objectives of MOA, and they muster resources for achieving the same and control, guide, direct, and manage the affairs of the company. Designation of directors is how we define by the articles of association. They can be designated as governors, members of the governing circle, board of management, other titles, but simply calling as directors. And if you go for referring section 8 companies, association and other bodies, they will not be calling them as directors or board of directors. Instead, we'll be calling them as committee or governing board of directors. Okay. Those who have joined now, I'm in page number 12.115. Okay, on directors. Thus, the directors will be having different capacity. Probably by name, we call them as different capacity. Okay. Senior management. So among that, we have a board of directors, right? Among them, we can be naming them as manager or whole-time director or managing director who will be holding a prominent position in the decision making. There's actually no difference saying like manager or see what is their nature of duty, what is their limit in the duty that will be executed directly. Okay. So there is no doubt in that. So, sorry for that. Continuing. And one important thing you have to make a note here is duties that will be assigned or detailed provisions are provided from the Act, but still, when you talk about the director's duty, he becomes the agent of the company, so everything has to be done. But a list of activities are given in the Act itself. Okay. From this case, the Andhra Pradesh High Court, in Deen Dayalu case, it says that a manager or other managerial person is not a director. So this might have discussed already in the session. You remember when we have the name called as managing director or executive director or independent director, he'll be what is a director because name itself contains the word director. If he is called as manager or any other capacity, CEO, he need not be a director. Okay. So if he fulfills the criteria of director, then only he can be designated as managing or executive or independent director. If he is not fulfilling the basic criteria of director as per that, he cannot be held as a director. Okay. What are the duties and responsibilities of a director? Obviously, we have to go for his efficient and prudent corporate management. So everything has to be done. Uh, in this Act 2013, earlier we did not have this. In this Act 2013 only, we have the section 166, which is defined for the first time in company law. What is that he can do or how we depend on him. So he shall the duties. Okay. He shall act in accordance with the articles of association will be mentioned. He will act in good faith. For what reason? To promote the objects of the company for the benefits of his members as a whole and the best interest of the company, probably his employees, the shareholders, the community, and for the protection of the environment. So this is a hot topic going now: sustainable development and sustainability of the organization, not the organization, the whole world. Okay, globalized. Third, exercise his duties with due and reasonable care, skill, and due diligence, then not involved in a situation that there may be arising some conflict of interest. Okay, he should not have personal interest in the company. That's what we call as conflict of interest. And he should not achieve or attempt to achieve any undue. Undue means what? Unfair. Unfair gain or advantage. Then either to himself or his relatives or partners or associates. And not only that, if such director is found guilty of making such undue gain, then he'll be liable to pay an amount equal to that gain. So he becomes personally liable. And please make a note of the sixth one. He cannot assign his office, and if any assignment is done, then this assignment will be made as void. If they are not following this section 166, then he will be penalized with 1 lakh rupee to 5 lakh. When we say director, Companies Act 2013 brought this numbering called as the director's identification number. So the director will be identified. See how we have our Aadhaar number, how the company has a SIN number. Likewise, director is identified by this DIN number, where one individual can have only one DIN number. Okay, if he's a director for 10 companies or 15 companies or whatever it is, he can be maximum director, whole directorship only for 20 companies. Okay, so if he's having directorship in more than one company, even then we can have only one DIN. So it's the DIN for identifying. This is the person so and so. Okay, so companies have says that person who wants to be a director should obtain a DIN. This is what you call as a director identification number. It's an identification number, and central government allots this number to any individual. Please highlight. There is no particular qualification. He can be so and so. Okay. So Companies Act and central government is not prescribing any conditions. Intending to be the director can be taken and to any existing director also, because we follow this from 2013 Act only. From earlier Act, it made compulsory that even though they were following the 1956 Act, they have to follow this. Okay. Then section 53 to 153 to 157 completely deals with all the matters related to till. Okay, see, as I was telling, you're not dealing in detail. We'll just go for the bird's eye. Whereas if you talk for section 153, so dealing with till, right? Application for allotment of till. Yes, individual shall apply who is intending to appoint as a director of the company in prescribed manner and as a prescribed fee. Central government will be giving any identification number which may be considered as till. Okay. Qualifications is there is no prescribed academic. Please highlight no prescribed academic or professional qualification for director. No mandatory share qualification unless if it is mentioned this in AOA. We will call this as director share. டைரக்டர் இது ஏன் கம்பெனின்னு நினைச்சா அவர் வந்து என்ன பண்ணுவாரு, ஓகே என் கம்பெனிக்காக வேலை செய்யவும் நல்லா வேலை செய்வாங்க. அதனால சம் கம்பெனிஸ் what they say is directors qualification share வச்சிருப்பாங்க. That should be mentioned in articles of association, else it will not be taken. Okay. Therefore, a director neither needs any minimum professional qualification or share qualification unless the articles such as this. Next, we'll go for section 164. Disqualifications for appointment of director follows from subsection 1. A person shall not be eligible for appointment as a director of the company if he is of sound-mindedness, okay, unsound-minded, and stands to be declared by the competent authority. So, authority வந்து so competent court வந்து சொல்றாங்கன்னா ஆமா lunatic மாதிரி சொல்லிடுறாங்க. He is undischarged, insolvent. Yes, he's been declared as insolvent and he's still in that insolvent stage. Then he's applied to be adjudicated as insolvent and his application is pending. Even insolvent சொல்லிட்டு கோர்ட்ல கேஸ் போயிடுச்சு. See, this is adjudicated. Adjudication means proceedings has been going on and the application is still pending, which means what? He's not been declared, but still the application is pending. Capacity and he might be convicted by any court for any offense which is related to moral turpitude or otherwise, and he has hold imprisonment less than 6 months is not an issue. If he has hold imprisonment for more than 6 months, 6 மாசத்துக்கு மேல ஜெயில் கம்பெனி எண்ணிருக்காருன்னா then he is not capable. But that 6 months, more than 6 months period is over, and how many years is over? ஆமாங்க ஜெயிலுக்கு போனாங்க எப்போ 5 வருஷம் is not அப்படின்னா okay. That 5 years clear record should be there. That's why. So 5 years has not elapsed from the date he will not be qualified to wear that. However, please make a note. They say 6 months, at least 6 months, okay. But what happens here is if he has made any crime and he has been offensed for and he has been penalized with 7 years or more in prison, means he is not eligible to be a director at all. Okay. 7 years மேல வந்து imprisonment போனா பெரிய crime ஆகும். So he is not capable at all thereafter. Okay, normal ஒரு employee மாதிரி இருக்கலாமே தவிர he cannot be a director. Okay. So that happens. Then E point, disqualifying order in force. Probably any court or tribunal says he's not qualified to be a director. Not paid call money. See, the company, see, board of directors are the persons who are authorized to call the money. நீங்களே கால் பண்ணி நீங்களே பே பண்ணலாம். Okay. So held around a agency if the money is not paid and 6 months elapsed, then it's fine. Okay. And 6 months elapsed, probably the call money is made at this time. And within the 6 months, he has to make the call money, that is, pay the money. If 6 months is over and still he has not paid, means then he is not qualified. Okay, அதுக்குள்ள pay பண்ணா then it's fine. Okay. Conviction related to related party transactions under 188 during the last preceding 5 years not qualified, and non-compliance with respect to section 152(3) and 165(1). This is relating to this requirement of DIN, and this is relating to how many membership, how many directorship we can hold. Usually we say 10 plus 10 equal to 20. Okay, but 10 plus 10 20 now. This 10 is for public company and not more than 10 companies public company, and remaining can be like private company. Okay, so totally 20 companies irukkalam. Maximum we can hold directorship for 20 companies. Is it okay? So can you just go through subsection 1 we have done. Subsection 2 of 164. See, even though 164 subsection 1 talks about the disqualification, this subsection 2 is a new section added. You are a director in a company. For example, you are Mr. X. Okay. You are a director in company 1 and also a director in company two. If you are not performing your job well in company one, you cannot be a director in company two also. So that's about the disqualification spoken in subsection 2. See, no person who is or has been a director of a company, this can be mean not the same company. In that company, he will become disqualified. And when he becomes disqualified, his din also becomes disqualified. இப்போ டைரக்டர் வந்து அப்பாயின்மெண்ட் ஃபார்ம் ஃபில் பண்ணும்போது என்ன ஆகும்னா அந்த டைரக்டர் குவாலிஃபிகேஷன் டிஸ்குவாலிஃபிகேஷன் இருக்குன்னே காமிக்கும். இப்போ டிஸ்குவாலிஃபிகேஷன் எடுக்காமீங்கன்னா அது என்ன எடுக்காது. ஃபார்ம் எடுக்கலன்னா he cannot be a director இல்ல. ROC has to accept இல்ல. He is a director appointment. Which company has not filed financial statements and annual returns continuously for three financial years? Continuously for three financial years. So that's why if any company clients talk to us, we say that whatever it is, at least for 1 year you file it. And we push the directors also to make the company file it. யோசிச்சு பாருங்க 20 கம்பெனில டேரக்டரா இருக்காங்க ஏதாவது ஒரு கம்பெனி சின்ன கம்பெனி ஆல்மோஸ்ட் அந்த கம்பெனி எந்த டிரான்சாக்ஷன்ஸும் இருக்காது அந்த கம்பெனி வந்து ரன் ஆகாத கம்பெனி எதுக்கு வரி பண்ணணும்னு நினைச்சிட்டு இருப்பீங்க ஆனா அந்த ஒரு கம்பெனி க்ளோஸ் ஆச்சுன்னா மிச்சதெல்லாம் அந்த ஒரு கம்பெனிக்கு நீங்க ஃபைல் பண்ணலாம் மிச்சம் எந்த கம்பெனிக்கும் நீங்க ஃபைல் பண்ண முடியாது ரைட் ஃபைல் பண்ண முடியாத ஸ்டேட்டஸ் ஏன்னா நீங்க ஆனுவல் ரிட்டர்ன்ஸ் எல்லாம் எந்த கம்பெனி ஃபைல் பண்ணணும் சொன்னேன் இல்லையா இஃப் யூ ஆர் டாக்கிங் அபவுட் கம்பெனி ஒன் ஹஸ் நாட் ஃபைல் ஃபார் 3 கண்டினியூஸ் இயர்ஸ் கம்பெனி டூ ஓட டைரக்டர்ஷிப்பும் எடுத்துக்காது நாட் only that ஆனுவல் ரிட்டர்ன்ஸ் ஃபைல் பண்ணணும்ல ஏன் நமக்கு டிட் நம்பர் கூட எடுக்காது. So obviously for the remaining 19 companies, all filings will be pending. And now you're pushed to make the company active. That first company active. Okay, so it's a beautiful provision actually. Not only with respect to filing of financial statements and other thing, also goes with respect to failure on non-repayment of deposits. Okay, which means what? Failure of repayment of deposit, which means non-repayment of deposits along with the interest, not redeeming debentures along with the interest, and non-payment of declared dividend. See, only when the dividend is declared. Declared dividends mean you're talking about the dividend to the equity shareholders. So it will be declared in the general meeting, right? So they shall be eligible. They shall not be eligible to be reappointed for a. See, we start with no person, so we shall say shall be eligible to be reappointed for a period of 5 years from the date on which a company fails to do so. 5 வருஷம் கர்ப்பம். Okay. Proviso, no disqualification for a period of 6 months from the date of appointment. Yes, probably if you are talking about the 6 months period, will not consider as a disqualification. Okay. And private companies can include other disqualification because this is my private company and it's a very closely held company. அப்ப என்னன்னா இவர்தான் வந்து டைரக்டரா இருக்கணும்னு சொல்லிட்டு you can talk டைரக்டரா இருக்கக்கூடாதுன்னு சொல்லிட்டு disqualification ஆட் பண்ணலாம் articles of association. That's allowed. Okay. Then let us go for appointment. Follows from subsection 1, section 149. Who can be as directors? It clearly says individual can be directors. Okay. Company, if it is a public company, minimum how many directors it can be? 3, maximum 15 directors. And if you want to have more than 15 directors in your company, yes, you can have. Up to 20 is allowed. Okay. But you need to file a special resolution. So whenever you go for passing a special resolution, you go for filing MGT 14 form. And moreover, further proviso, in some prescribed companies, there should be at least one woman director also. Is it okay? There should be at least one director also. In other cases, yes, we will be having the first directors. Probably they'll be appointed. Some directors will be appointed. Rotational directors will be going for reappointment at general meeting. We'll be having resident directors, individual directors. Probably the board of directors is given the authority to appoint additional director or alternate director. They call us alternate director now. There is director A who is going for out of station. He will not be in India for 3 months. I think 3 months. So 3 months is 1 quarter. So continuous 3 months is not going to be in India. Now who is going to take care of his job, of his control and other affairs? So there will be one person alternating his job. So we will be calling as alternate directors. All these provisions will deal it and deal in final. Okay, so just we are defining alternate director. And nominee director, the public financial institutions who has provided the financial assistance to the company, what they do is they want to have their one representative as a director over there. So they will have nominee director. Okay, nominee director is the director for the company, but see how we have like debenture trustees. The same like this person will be the director for the company, but at the same time they will be in case you are borrowing for further loan or in charge creation is done, they'll be saying that they cannot be taken. Okay, and sometimes it happens we have to fill the casual vacancy. They have to be younger or some problem like we need to fill the gap because for public company we need to have at least 3. So one director has passed away, only 2 is there. So automatically the remaining 2 director has to bring one director over there. They cannot wait for the general meeting to take place. Okay? So this is one thing. Then we'll go for retirement and rotation of directors. So when we say directors, ஒரு வருஷம் கம்பெனிலே இருந்தாங்கன்னு வச்சுக்கோங்களேன், அது நம்ம பிசினஸ் மாதிரி ஆயிடும். So see, if you are working for another company, you say, okay, நான் கரெக்டா வேலை செய்யணும், இது என் கம்பெனி இல்ல. See, what we say is we should be detached. If I feel or if I make a sense that this is my company, அப்ப அதுல வர லாபம்னா டைரக்டருக்கு என்ன வரும் தான் பார்ப்போம். That should not be done. So that's why we say that we'll go for rotation of directors. Who joined very beginning, he'll be retiring first. Okay. So depending on the date of joining. So it follows from section 6, 152, subsection 6 of 152. For public company, while provided by articles of association, all the directors can be called for rotational directors. But all will not be retired. All will be called as rotational directors, but all will not be retired. For example, there is my company, public company, having 9 numbers in total, 9 directors. General case, two-thirds of the directors will be determined for the retirement by rotation. Two-thirds means how much power? 6 directors. In the 9 directors, 6 directors வந்து the rotational directors. So, but எல்லாருமே போக மாட்டாங்க. அதுல வந்து 1/3. From the 6, we have to take 1/3. So how many? 2 directors will go as rotational directors. And in the GM, general meeting, they can be reappointed also. So you remember the ordinary business, adoption of financial statements, declaration of dividend, then we'll go for appointment or reappointment of rotational directors. So that's about the statement only. Okay. And it should be expressive. They should be clearly appointed by the company in the general meeting. The remaining directors whom we call as non-rotational or non-retiring, or we call them as permanent directors in case of a public company shall be appointed as per the provision. Where a director retires by rotation at the AGM, the company, the same meeting, they can appoint it. If they want to continue this directorship, this qualification is very good that it's needed for the company. Most of the time, they'll be needed for the company. ஏன்னா வருஷம் வருஷம்லாம் மாத்திட்டு இருக்க மாட்டாங்க. You just remember, ஒரு இடத்துல புதுசா போய் ஜாயின் பண்றீங்க. மினிமம் 2 3 மாசம் ஆகும் அந்த வேலையை கத்துக்கிறதுக்கு. வேலை கத்துக்கிறதுன்னா எந்த வேலை யார் பாக்குறாங்க, just adopt to that environment, right? So definitely take minimum of 2 or 3 months. ஒரு வருஷம் வருஷம் அனுப்பிச்சிடுவாங்களா வெளியில. So it's not why they say is when we talk about this passing of resolution in the general meeting, the persons, the shareholders, they get the right to pass a resolution in the meeting. அப்போ அவங்களுக்கு ரைட்ஸ் இருக்கும்போது the full control is taken over not by the board of directors but by the shareholders. That's why we do it. Then section 168, resignation of directors. The director gives a notice in writing to the company. Board of directors will take note. Company will be filing this form called as 1-2. Director 12. DIR stands for Director 12 form. Within how many days? 30 days of the receipt of notice, and he has to post the website also. Not only that, he has to place the fact, the immediate GM. Director has to forward his concern. It's not concern. Resignation reason. எதுக்காக நீங்க ரிசைன் பண்ணீங்கன்னு சொல்லிட்டு ரீசன் கொடுக்கணும். அந்த ரீசனுக்கு ஒரு ஃபார்மேட் இருக்கு. அந்த ஃபார்மேட் பேர் நம்பர் வந்து DIR 11. Actually, this is form. This is format. But usually we say that format name as form only. Okay, usual format. Within 30 days to the register. So that's subsection 1. Subsection 2, effectiveness of resignation. So from which date they are resigning. Okay, so probably we had to talk in this angle. Just remember 25th September he is giving the resignation date. Okay. But the board of directors meeting is held on 30th September 2025. Okay, 30th September 2025. Okay, tell me from which date he is away from the company. This date or this date? Access, which was earlier. Okay, date of notice received or date specified in the. He is giving the notice at this date. Okay, and date of notice received is 20. Date of notice received is 30th. So which one he has to? So from this date onwards he is not eligible. So அதனால என்ன பண்ணுவாங்க, board of directors meeting வந்து they'll be clearly mentioning whether it's 25th September or 30th. So sometimes they'll be saying that immediate effect. Immediate effect means for 30th September immediate effect. Sometimes they will be saying that taken to the date specified in the notice. So it will go from 25th September. ஏன் எவ்வளோ டிஸ்கஷன், ஏன் இவ்வளோ இம்பார்ட்டண்டா அதை பார்க்கணும்னா, if this director has signed any document or agreement with any other company or any other third party, we need to check whether that contract is void or valid, because he should have the authority, right? Is that doctrine of constructive notice? Okay, the outsider will check whether director has signed it. As a company, you need to check whether he is having the authority. Outside it will become safe. இப்போ கான்ட்ராக்ட் வேலிடா வாயிடா செக் பண்ண ஸ்டேட்டே இதுதான். director தானே மூவ் பண்ண போறான். They will go for subsection 3, resignation or vacancy of all directors. If this happens for one company, what it happened is all the directors were traveling for a business meeting and they met with an accident and all passed away in that spot itself. அப்போ எல்லா directors காலி. Company, even a bomb is there, okay, even it's bomb, the company will be having the perpetual succession. So all the directors were resigning or vacancy has arisen with appointment of required number of directors has to be done by the promoters or the central government meeting. If there is no promoters to be identified, the central government will be taking them. So you have the case laws, you can go through it later. Removal of directors, yes, who can remove? By shareholders or by tribunal? If they want to be removed by the shareholders, actually when you talk about the shareholder, they have a list of rights. Among that, one right is that right where the directors can be removed. Follows from section 167. It is not necessary that there should be proof of mismanagement. Please highlight. Sorry, manage panel, breach of trust, misfeasance, or others. Not only that, if they feel like that this director is not suitable or he is not taking the company to the next level, அப்ப எதுக்கு the director? அப்படின்னு நினைச்சாலும் ஒத்துக்கலாம். And by the shareholder fees, the policies pursued by the director or any of them are not of their liking. See, we are the company, shareholder of the company, not director's company. Director are the agent and trustees of the company. Shareholders are notional owners. So they have the complete right. Okay. So they have the option to remove the directors by passing an ordinary resolution the same way as they have the right to appoint the directors by passing the resolution. Okay. How removed and appointed? Yes, by ordinary resolution we have checked. And after giving a reasonable notice, see, எக்ஸுங்கிற டேரக்டர் எவ்வளவு வருஷமா கம்பெனில வந்திருக்காரு திடீர்னு தூக்குறீங்கன்னா அவருக்கு ஒரு ஆப்பர்ச்சுனிட்டி தரணும். Right? Something might have happened. So you need to give them opportunity to discuss and answer. Okay. So after this, once an ordinary resolution is passed, his office vacates automatically. New director is another director has to be appointed in the same meeting and a special notice is intended of his intendment of appointment has to be provided. And this newly appointed director will be holding the post until the duration up to the new formal appointment of the director's name. See, he has been appointed immediately. A இருந்தாரு A தூக்கிட்டாங்க B வந்து immediately appoint பண்றாங்க. So there should be they will be having this formal letter of appointment along. Consent letter தரணும் director and formal letter of appointment has to be sent by the company to the director and they have to file a form over there. நீங்க ஆர்ஓசிக்கு இதெல்லாமே பண்ணோம் இல்லையா சோ அதெல்லாம் போயிட்டே இருக்கும் பட் அப்புறம் என்னது டைரக்டர்ஷிப்ல ஹோல்ட் பண்ணிருக்கோம். So liability of the removed director is for the damages and compensation which is required to be payable to him in lieu of his removal and termination. So you can go for this case now. Removal by tribunal. Okay, probably then we are discussing with respect to shareholders has the right to remove. Here, tribunal is given the right to remove under this section 242. Tribunal might be terminating or setting aside an agreement made with any of the directors, probably like service agreement or something, without the entire level. And an application can be made to the tribunal by which section 241. So apply பண்றீங்க apply பண்ண பிறகு remove பண்றாங்க. எதுக்காக இதை அப்ளை பண்றீங்க அப்படின்னு பாத்தீங்கன்னா அகேன்ஸ்ட் ஒப்ரேஷன் அண்ட் மிஸ்மேனேஜ்மெண்ட். See, if you're going to the tribunal means there should be something wrong happening. அப்போ அந்த ராங் வந்து தெரியப்படுத்தணுங்கிறதுக்காக ட்ரிபியூனல் மூலியமா and the tribunal may be ordering for the removal of any of the directors of the company. Effects, if they have gone through the tribunal's order means obviously that director will not get any compensation. See, earlier we said that they'll be receiving the compensation, but here they will not receive any compensation for the loss of office. And not only that, they cannot serve as a manager or managing director or director of the company without leave for a period of how many years? 5 years in any other company. Okay, unless tribunal might be giving this thing as not 5 years or something. Usually on the money order pass 5 years they cannot be in any director or manager or whatever it is. அதையும் மீறி இருக்கணும்னா ட்ரிபியூனல் வந்து மென்ஷன் பண்ணி தான் மட்டும் தான். You should be expressive in nature. Okay. Remuneration follows from clause 78 of section 2 the Companies Act. Any money or its equivalent given or passed to any person for services rendered by him and includes perquisites also. Please highlight. And includes perquisites also. Perquisites continuing. Overall maximum remuneration, how much it can be. Okay, this is a quite famous section. Probably you can expect this as overall question or a manager name will be given and a designation or a position will be given. and you will be asked to calculate the managerial remuneration. Overall managerial remuneration follows from the section 197. So you can expect this as theory question or database question or practical question may be given. And also the same weightage is given for the final level also. Okay. Follows from subsection 1. Overall maximum the managerial remuneration can be, we have to get a trial approval, okay, for passing the special resolution. In case of default is there in, we have got any bank loans or public financial institution. If you have any default in the payment of the bank or financial institutions or NSD, non-secured debentures or any secured creditor, then in that case, before passing special resolution, you need to get the approval of them. பாருங்க அவ்வளவு கடனை வாங்கி வச்சு அதே திருப்பி தர முடியலையா நீங்க டைரக்டருக்கு ரெமுனரேஷன் தரீங்களா கேட்பாங்கல்ல. So that's about that content. And not only that, auditor certificate or remuneration should be paid. It is within the limits. Who is the person entitled to get the remuneration in this column? What is the maximum remuneration in any financial year in this column? And in case if the remuneration exceeds this maximum level in any financial year, what you have to do? Okay. Generally, this first, let me go line by line. Okay, please take care. First one, we are talking about managerial remuneration, which means what? We are giving remuneration to the directors. Who do you call as directors under this point? Includes managing director, full-time director, and manager of public companies. How much they can be given remunerated? 11% of the financial year's net profit. Okay. For this, you have to pass resolution in the general meeting, ordinary resolution submission, and you have to follow Schedule 5. Why Schedule 5? Because we are calculating from the net profit. So you have to follow Schedule 5. And this second, third, and all. See, first one is a major one. Second one says, first one, when you talk about director, it includes all the directors, including managing director, full-time director, and everybody. If your company is having a managing director or full-time director or manager, one, see how many? One. Then for that one person, maximum how much you can give? 5%. If your company is having one managing director or one full-time director or one manager, how much you can give? 5% of the financial year's net profit. And you have to pass special resolution. See the third point, continuation to this. It's not like this one or that one. It's in continuation. Third point, if there is more than one managing director, in company managing director or full-time director or if there is more than one managing director or full-time director or manager, you will pay 10%. See, my company is having managing director and two full-time directors. See, a company cannot have managing director and manager. Exactly, Sulima. Because managing director's role and authority is the same as manager's role and authority. Managing director, he is a director and managing director. Manager, he need not be a manager. See, the name is not including director role. So, managing director and the manager இருக்க மாட்டாங்க ஒரு பொசிஷன் தான் இருக்கும். See, I am the boss of you, for example. I am the boss of you. If you are doing anything, to whom you have to report? To me. Just think the reverse way. You are the boss of me. If I do anything, whether it's good or bad or as per the designation, whatever I do, who's taking the control? You are taking the control of me because you are the boss for me. Now what happens is, I am the managing director, you are the manager. We are at par role. அப்ப நீங்க எனக்கு ரிப்போர்ட் பண்ணுவீங்க நான் உங்களுக்கு ரிப்போர்ட் பண்ணுவேன் அந்த மாதிரி ஒரு அத்தாரிட்டியே இல்ல. See, reporting na, they should be like superior and inferior roles. We cannot have the same power roles as reporting authority. So we cannot have that. That's why companies are serves as managing director and manager or company இருக்க முடியாது. Okay. For example, let me take for the third case. One managing director and two full-time directors are there. What the second case says, for one person, how much you can pay? 5%. Okay. So in a 5% now, it comes to totally 15%, right? But what's the overall manager 11% only? See, what this third point says is, if there is more than one managing director or full-time director or manager, put together is 10%. அப்படின்னா மூணு பேர் இருந்தாங்க ஸ்பிளிட் பண்ணிக்கோங்க. It's not like equal and all. Okay. See, for managing director, you may be paying maximum 5%. For managing director, you may be paying 4%. For remaining 3 and 3, can be anything. So put together how much you can pay? 10%. And for so on also you have to get the resolution passed. Then directors, the next one. We have directors. He's not a managing director or full-time director. Okay. In this case, how much you can pay? Maximum of 1% of net profits. If there is a managing director and full-time director. My company. Okay, let me clean the board once again. see this point. Actually, both the points I shall discuss. If my company is having X, Y, Z, okay, this case, Z is the managing director. Okay, we are talking about the remuneration of who? X and Y. How much you can pay for X and Y put together? 1%. Because why? If there is a managing director or full-time director is there. See, Z is a managing director. In this case, neither managing director or full-time director. See, this X and Y are not managing director or full-time director. How much I can pay? Still 1% of the net profits. Okay, so maximum in the full-time director, managing director or manager இல்லைன்னா உங்களுக்கு வந்து 1% மேல இல்ல. That's what I'm trying to say. Okay. So, if you go for 197 subsection 8, computation of net profits has to be calculated as per section 198, except that the remuneration of the director shall not be deducted from the gross profit. Yes, ma'am. Please highlight. So, we find the gross profit, then we go for net profit. While calculating gross profit, usually என்ன பண்ணுவோம் remuneration to the directors, salary to the directors மாதிரி தானே அதை டிடெக்ட் பண்ணி தானே gross profit வரும் usual calculationக்கு. பட் இங்க என்ன சொல்றாங்க அதை மட்டும் கன்சிடர் பண்ணாம calculation. Okay. Remuneration rendered in any other capacity. Okay, yes, can do it. Apart from being a director, is rendering any other capacity. Obviously, you can do it, but that should be mentioned in articles of association. And you have to pass a ordinary resolution. If you mention in the articles of association, we need to pass special resolution means yes, we need to pass a special resolution. Okay. So when you say the director here, it includes managing director, full-time director, manager. So normal director இருந்தாலும் பரவாயில்ல, managing director, full-time director, manager. It includes services rendered by him in any other capacity, probably in any other professional capacity. Probably just imagine there is a lawyer, okay, who is a director of a company. Company வந்து ஏதோ ஒரு கேஸ்ல போகுது. Okay. There will be a legal team working for the company. Lawyers இருப்பாங்க. But in addition to that, what the company, the board of directors senses, see, he's a well-renowned lawyer. Why we not ask him also? Because he's a director. அதனால இவரோட கெப்பாசிட்டில வந்து we are going to have extra work extracted from him. We have to pay for him, right? See, அவன் human being தானே கம்பெனிக்காக பெற்றுக்கொள்ள வரும். So, கட்டாயம் அவரோட சர்வீசஸ்க்கு வந்து நம்ம ரெமுனரேட் பண்ணுவோம், காம்பன்சேட். Okay. And does not include in professional nature and in opinion of NRC. Yes, please highlight. Professional nature வராது. Okay. Because இந்த lawyers தான் வந்து இவங்களுக்காக தான் lawyers இருக்கனால தான் போட்டிருப்பாங்க directors தான். So professional nature பார்ப்பாங்க. And probably the NRC committee, NRC's nomination and remuneration committee says whether they process the particular requisite qualification. Okay, so that has to be checked. Yes, sitting fees will be given to the directors for what? Attending meetings to board or committee. How much you can pay? Not to exceed 1 lakh per meeting. Okay. However, for independent directors and full-time directors, the sitting fee shall not be less than the sitting fee payable to other directors. Okay. So, independent directors for full-time directors for not full-time, women directors. Women directors for WT is women, WTD is full-time. Okay. So, we are not talking about full-time, we are talking about. So, probably different fees may be prescribed for different classes of companies and different fees for regional directors also. Mode of remuneration, monthly you can pay it, or we can do it as specified percentage of the net profits or partly of both. No profits or profits are inadequate. So no remuneration. Okay, in case no profit in the remuneration is 11% net profit. No profit is how you do. So no remuneration. Okay. Probably this includes for all the three, except as mentioned in Schedule 5. In case you are not able to comply with the Schedule 5, probably you have to get the previous approval from the central government and you have to follow. This Schedule 5 is applicable for increase from what MOA or AOA, probably or giving an increase now, or by agreement or by general resolution or both waiting. You have to get the approval of the CG. Remuneration for independent directors, yes, please highlight they are by name they are independent, so you are not entitled to give any stock option to them. Remuneration எப்படி வரலாம் உங்களுக்கு by way of sitting fee, only 3 modes. Okay, by way of sitting fee or reimbursement of the expenses for participation in the board meetings. So மத்தவங்க அட்டெண்ட் பண்ணிட்டு போறாங்க இல்லையா, independent directors வந்து they will not be involved in the day-to-day work. See, they are independent, which means they should not associate with the day-to-day activities. The outside works தெரியணும். நான் என் கம்பெனிக்குள்ளே இருக்கிறேன், என்ன நடக்குதுன்னே எனக்கு தெரியாது. அப்போ வெளியில எனக்கு தெரிஞ்சா பார்த்தா தான் எனக்கு தெரியும். So அந்த சென்ஸ்ல independent director will come for the board meeting only for attending the meeting. Otherwise they can reimburse their expenses. And moreover, When we say directors, they will be closely connected. Probably they will be more or less connected in the same area. I'm talking about geographical locality. Whereas we talk about independent directors, இங்க இருக்கிற நார்த்ல இருக்கிற தமிழ்நாட்டில் இருக்கிற கம்பெனி வந்து நார்த்ல தான் வருவாங்க. Only for doing the attending the board meeting. So that's why we have to check this. And profit related commission as may be approved by the members. Okay, so three modes, and this mode is totally avoided because the independent nature will go. Okay. Refund of excess. So, in case you have paid anything excess and you have not got the prior permission of the central government, then you can hold in trust of the company until refund. Which means what? You become the trustee for the money. As if you're a director, you have your excess drawn from the company. Means you are holding the money. It's not your money. You're holding the money in trust of the company. So you become the trustee for the money. Okay. So no waiver of recovery unless permitted by the central government. So probably central government may be saying whether you can be going for waiver for recovery or not. What do you mean by the waiver of recovery? பரவாயில்ல எக்ஸ்ட்ரா பே பண்ணிட்டாங்க அப்படின்னு சொல்லிட்டு நீங்களே வச்சுக்கோங்க சொல்ல முடியுமா? இது வந்து வேலை செய்யறாரு இந்த டேரக்டர் காலைல வராரு நைட்டா அவர் தான் ஷட்டா மூடுறாரு அவர் தான் ஷட்டா திறக்கிறாரு அப்படின்னு சொல்லி நீங்க அவருக்கு எக்ஸ்ட்ரா பே பண்ண முடியும். Ana, if permitted by the central government, you need to recover. That's what no waiver of recovery. Okay. So that's about this heading. Yes, if it is a listed company, you have to go for disclosing in the board's report. Remuneration of each director has to be reported. The medium employees' remuneration and other details under the company's rules also has to be given. To include a statement, what you have to do is you have to give the employee's name. Okay, employment with respect to the financial year, aggregate remuneration not less than 60 lakhs. See, for the financial year, which means complete 12 months. Okay, usually we take it as 12 months. Okay, so aggregate remuneration not less than 6 lakhs. So for 1 lakh, you can pay maximum of for 1 month, you can pay maximum of 5 lakhs. Oh, 5 lakh, மேல போயிருக்கணும் automatic என்ன ஆயிடும் போஸ் ரிப்போர்ட்ல அவரோட நேம் தான். And employment is not for the full financial year, but part of a financial year means aggregate remuneration not less than 5 lakh per month. Okay. And employment for financial year or part of the financial year, probably aggregate remuneration in excess of drawn by managing director, manager, full-time director or manager. I witnessed a company, he is an engineer for the company. மேனேஜிங் டைரக்டர்லாம் 2 லட்சம் ரூபாய் 2.5 லட்சம் ரூபாய் தான் இருக்கு. ஈவன் 5 லட்சம் ரூபாய் வாங்க. சாரி நாட் 5 லட்சம் ரூபாய் 3.95 lakhs. 3.95 lakhs. See, for A point and B point is okay. The C point says this engineer is getting a salary for less than 5 lakhs only per month. But he is drawing in excess of managing director and other persons. See, we are talking about the remuneration and we are talking about the disclosure of the managerial remuneration. But this engineer, chief engineer of the company, is not a director belonging to the board. Right? But still, he will not biggest salary தராங்க. அதனால disclose பண்ணணும் சொல்லி. Okay. As per that, we have to disclose. Or he might be holding 2% of the equity shares along with his spouse or dependent children. Okay. 2% is more than that. He'll go in lakhs, he'll go in crores. He's not a director, he's not belonging to the promoter or nothing. He's just an employee, but how much he's holding the shares? 2% of the equity shares. Okay, along with the spouse or dependent children. நான் சொல்றேன் என் பேர் இல்லைங்க என் ஒய்ஃப் தான் வச்சிருக்காங்க என் ஹஸ்பண்ட் தான் வச்சிருக்காங்க என் பசங்க 8 பேர் இருக்காங்க 10 பேர் இருக்காங்க வச்சு அதெல்லாம் இல்லை நீங்க வச்சிருக்கீங்க because you are having highly connected with the company and you are in employment. இப்ப கொஸ்டினே அதான் எம்ப்ளாய்மெண்ட் வந்து எப்படி 2% ஷேர் வச்சுக்க முடியாது கொஸ்டினே. Okay, probably he might be saying எங்க வீட்டுல வந்து ஒரு சொத்து இருந்து அதை சொந்த with reasons whatever it is, but you are highly connected. 2% வந்து சின்ன வேல்யூபிள் பெரிய வேல்யூபிள். Other related particulars designated. Who is he? Managing director or whatever it is. Remuneration regime, nature of employment, qualification, experience, date of commencement of employment, age, last employment, percentage of equity shares held. Is he a relative of any director or manager of the company, or we have to mention? So that's about this heading. Shall I take over? Shall I finish it off? Insurance for indemnification, the key personal insurance for shipping and accident. So it should be taken by the company because these persons, managing director, full-time director, and manager, CEO, CFO, CS, they are all very important persons of a company. Okay, they are actually belonging to the management directly. Okay, so when they leave the job, okay, or not only leaving the job, so when any liability occurs because of the negligence or default or misfeasance, or they're not doing that duty well, breach of duty or breach of trust, and they were found guilty, and that's creating a liability to the company. Now, liability when the company being an artificial person, how it can take the full liability. That's why it can go for providing this insurance. Okay, and this premium amount paid for the insurance should not be considered as a remuneration. நீங்க எங்கேயாவது போயிட்டீங்க, நீங்க ஏதாவது தப்பு பண்ணிட்டீங்கன்னா உங்களுக்காக தாங்க இன்சூரன்ஸ் பே பண்றோம். ஆனா ரெமுனரேஷன்ல குறைக்கணும்னு சொல்லக்கூடாது. இதான் சொல்லிட்டாங்க. பாருங்க ஆக்ட்ல சொல்லியிருக்காங்கன்னா அது எவ்வளவு இம்பார்ட்டன்டா இருக்கும். அப்ப எத்தனை கம்பெனி பண்ணிருப்பாங்க அந்த மாதிரி. Provided that if proved to be guilty, please highlight. Okay, if proved to be guilty, the premium can be treated as remuneration. Is it okay? Apart from that, sometimes the directors might be receiving commission also. So any director, he need not be disqualified from receiving any remuneration or commission. Probably he might be receiving not only from my company, but holding or subsidiary company also. But whatever it is, please disclose in the portion. And if you are not following the provisions of the all these sections, then penalty 1 lakh to 1 lakh rupee. And for company it is 5 lakh rupee. For director is 1 lakh and company it is 5 lakh. So till there is one heading one. Glass forming members. Power of the board of directors is quite an important section because this section 179 clearly tells, see, you're the management team, you're running the company each and every time. ஒரு புட்டுவசி வாங்கலாமா, ஒரு பென்சில் வாங்கலாமா, ஒரு ஸ்கேல் வாங்கலாமா, யார்கிட்ட கேட்க வேண்டாம், ஓனர்ஸ் கிட்ட கேட்க வேண்டாம். அப்போ see, I'm just telling us புட்டுவசி. It's not exactly புட்டுவசி. Okay. அதனால Act has given the particular powers where the board of directors can execute with no higher authority, which means what? Higher resolution pass பண்ண போறோம். So, subsection 1 says it can exercise all such powers, do all such acts and things as the company is authorized to exercise and do proviso, subject to the act you have to follow, memorandum of association you have to follow, articles of association you have to follow, and if any regulations is there you have to follow, and it should not be inconsistent to that. And everything has to be included in the if there is any inconsistency, authority meaning you have to go for G. Okay. Proviso further, if you exercise this, or if it is something given where you have to see, somewhere we find that past ordinary resolution, somewhere we find that past special resolution. Okay, which means what? The board of directors have no authority. It's understood, right? Because you have to pass a special resolution, means board of directors are not given the authority. Okay. And subsection 2 says you cannot not invalidate the prior acts. Probably he has resigned from the job. Earlier, I was signed the documents are valid. Okay. Subsection 3, yes, this is a list. See, 179 is detailing the provisions of powers of the board of directors. Whereas if you go for subsection 3, it's particularly telling what they can do. Okay. See, first one, to make calls on shareholders with respect to money unpaid on the shares. To authorize buyback of shares. To issue securities, including debentures, whether in India or outside India. To borrow money, to invest the funds, to grant loans, or to give guarantee, to provide security, to provide financial statement, sorry, not provide, to approve financial statements and the board report. See, one of the ordinary business in the annual general meeting is, very first is adoption of financial statement. Mati potraru. Ordinary resolution is adoption of financial statement. Here, the board of directors have the power to approve financial statements. Our board of directors approve பண்ண பிறகு balance sheetல financial statements each and every page directors sign. Director, managing director, company secretary, இவங்களோட sign இருக்கும். இதெல்லாமே நம்ம அடாப்ட் பண்ணிக்கிறவங்களுக்கு தான் ஏஜிங் ஆகும். Okay, aging, once இது வந்துச்சுன்னா you cannot raise a question. Obviously, if you find any mismanagement is there, you can ask them. And the funds improper use பண்றாங்கன்னா you can ask. But you cannot say that unless it is, okay, இது check பண்ணிப்போம். சும்மா ஒரு question raise பண்ணுவோமே அப்படிங்கிறதுக்கு rights இருக்காது. Okay. And to diversify the business of the company, to approve amalgamation, merger or reconstruction, to take over a company or acquire a controlling or substantial stake in an investment, another company or any other matter related to proviso. Yes, you can delegate this duty to any as a board of director, not as a director. Director delegate பண்ணது rights இல்ல. You have to do your duty. But when you call about the collective body, the team, that team can join and ask a committee, probably audit committee. A subset of the directors, okay, managing director or manager or other principal officer, you can ask them to do that work. So director does not have the right to delegate the office, whereas the board of directors has the right to form a committee and delegate the office or any appoint any for property sale பண்றாங்க ஒரு director authorize பண்ணலாம். They can do it. And for branch office, the principal officer of the branch office, the powers will be specified as maybe the conditions again. Further proviso, for banking company, acceptance of deposits happens to be an ordinary course of business, so they can receive the deposits of money from the public, repay it from demand, can be withdrawal by check or draft of order. This we have discussed in the deposit system. For a banking company, எது வாங்குதுன்னா the deposits இல்லைன்னு சொன்னா. Receipt of money is not a deposit for a banking company. And placing of money on deposit by a banking company with another banking company also maybe shall not be deemed to be a borrowing of funds. Okay. So we have to make a note of this one. So the 12.3 discussing on operational and financial control. When we talk about the types of control, we usually say financial control and operational control. Financial control is dealing with the daily accounting operations, whereas operational control is dealing with one particular unit. See, operations don't think this is about production or management. Operation means the department of operation. Okay, the unit of operation. Okay. What does it include? Probably you're going to check with the accounts, payroll systems, accounts payable and receivable. So probably you'll be planning how you're going to manage this regulatory things and all related to accounts. Whereas if you go over the side, if we will talk about reporting, budgeting responsibilities, including fiscal reporting for a particular unit with the large company. So we'll talk about particular unit. Here we'll talk about complete accounting side. Okay. Then two controls, the distinct role, two places. Here we the person called as the controller, financial controller. Here the person will be called as the operation controller. So the job title will be clearly specifying what is his responsibility towards that unit. So for business to basic business it will be very far. But whereas for financial control you are all see whether this company or that company, depending on the different sizes, your all function is related to financial side only. So you'll be having a normal job. So once you become a CMA, if you go for a organization, you may be called as financial controller also. So that's about this is small heading actually. 12.4 I'm not going to discuss today because that's covering the major heading. Okay, the topic like 12.2 to 12.6 is covering a major unit, so I'm not going to deal 12.4 now. 12.4 I'll do it in the next class. But I'll go for the next topic 12.5 and 12.6 because if I take that topic, it will take solid 1 hour. So I don't want to drag it, and that's somewhat a vague set of provisions now. So let me go for 12.5 directly. 12.4 we'll do it in the next section. 12.5. This is quite an easy one. Shall I take over? Rights of the shareholder. See, when we say shareholder, they are the owners of the company. Actually, we should not call owners. We have to call them notional owners. Surplus in the That's why we call them as notional owners. Okay. But still, they are the owners like right? Owners like company. And please remember when we say shareholder, usually we get this confusion whether they are members. Usually we'll say member only. Okay. Then member is what? Their name is there in the register of member. He need not hold a share. He need not be a shareholder, but his name is there in the register of members. He becomes a member. Okay. So first a member carries from clause 55 of definition to member in relation to a company means the subscriber. Okay. When you go for subscribing the memorandum of association, he deemed to become have agreed to become member of the company, and on the company's registration, he is entered as member in the register of members. Then every person who agrees in writing to become a member of a company or whose name is entered in its register of members, and every person holding shares of the company and whose name is entered in the beneficial owner in the records of the depository. If you are holding demat shares, your name will not be there in the company's record. Your name will be in the depository's record. NSDL and CDSL on the name like that. So we have some case laws. So let me go to the second one. Sant Chemicals Private Limited is Xavier Chemical Private Limited. A person whose name is not entered into the register of members of the company cannot be treated as member. Not only member, cannot be treated as deemed member also. இன்னொரு board meeting வந்து name enter பண்ணிடுவாங்கயா அப்படின்னு சொன்னாலும் ஒத்துக்க மாட்டோம். Okay, that's why we have something called as closure of books, closure basis only, where the books will be closed. See, if a company is going for AGM, going to declare the dividend and all, they close the books, the books of accounts and all this register of members will be updated over that time. The books will be closed, and that has to be done for the maximum of 45 days in a year. After that, we cannot close for more than 30 days. So, on the time on the end transaction, if the books is closed from start to end, till the end date, whatever the transaction is there, the register of members book will not be considered. The closure date முன்னாடி இருக்கிற ரெஜிஸ்டர் members bookல அப்டேட் பண்ணி போடுறாங்களோ அது வந்து தான் ஓகே அதனால தான் நீங்க டிவிடெண்ட் வாங்கணும்னா இந்த டேட்குள்ள டிரான்சாக்ஷன் பண்ணியிருந்தா தான் வாங்க முடியும்னு சொல்லுவாங்க. So fundamental difference between a subscriber and member. So subscriber who agrees to take the share at the time of formation. Yes, the company is not formed, right? It's not formed, but you agree. That's why we call them a subscriber. Okay. And member who agrees to take the shares during the issue. This subscriber becomes member immediately on incorporation. This person becomes member only after his name is entered in the register of members. If it's not entered, means he will not be called as a member, but still he will be called as a share. Okay. So from the analysis, we can say the following is a member subscriber to the memorandum of association at the initial stage of the formation. Okay. Two prerequisites are required. Okay, second case, two prerequisites. If he gives in writing that I'll agree to buy the shares and the registration of his name is there in the register of members. Okay, in what mode? By subscribing to the further of in shares. Okay, else on transferring it. I transfer the shares to you and your name is being taken to record. So on transfer of shares or on acquisition or purchase of the shares, like takeover bid also may be there. And on acquisition of the shares with devolution, like transmission of shares remember at the town of Aradalia. Now, because of merger and amalgamation, see X company and Y company amalgamate and form XY company. You bought shares in X company. Okay. Yourself some XX name. Myself YY name. I bought shares in Y company. You are a member of X company. I'm a member of Y company. If a புது company form ஆயிரும் automatically XY company will be giving shares both to shareholders of X and both shareholders of Y. Upon their name will be taken to record. Should be taken to record. அப்படிலாம் member இல்லைனா. Yeah. And probably if you have issued convertible debentures and it's mandatorily convertible or loans or that it is convertible in nature to equity shares, then this will go. As beneficial owner, we have to hold demat shares. If you hold demat shares, that's enough because your account details and everything are held by the depository. And depository is held by the depository means depository name is there in the register of member books, so it will become so it's quite an easy job. Yes, we'll go for the rights by contract or through MOA or AOA. Name has to be entered on the register of members book. Okay, obviously, then only you get the right. So that's why we listed that's first one. We can vote at the meeting of members. We can receive dividends when declared. We can exercise the right of preemption. Preemption rights means which rights you can execute before. Okay, for example, right to shares is all. Okay, return of capital on winding up if there is a surplus, or you can go for getting the amount return during the reduction of share capital. இப்போ பணம் வந்து எக்கச்சக்கமா இருக்கு ப்ராஃபிட் எக்கச்சக்கமா இருக்கு 10 rupeesல 7 rupees paid 3 rupees unpaid. Okay, well, probably the company is planning to give 2 rupees back to the shareholders, so you have the right to receive that 2 rupees. Okay, so what will be your remaining liability? Not 5 rupees, 3 rupees only. Remember the reduction modes of different reduction, yes. By contract or sometimes not by contract, certain rights can be executed and they'll be entitled to bring action to restrain the company from doing an ultra vires act. Okay, and to attend and take part in the proceedings of the meetings and to move amendments. If they want to amend the company's provisions, yes, they can amend it. Okay, through MOA and EMO. Thus, by general, here we'll go section by section. Section 47 says you can vote at all meetings. Section 100 says you can request for an extraordinary general meeting. 101 says you can receive notice of a GM. 105 says you can appoint proxy and inspect proxy register. So related to general meeting. 113 says in case if the members of body corporate, the right to appoint a representative is there. Okay, he cannot go, the company cannot go in person. So company gets a right to appoint a representative. Okay. 111 to require the company to circulate resolution. 56 to have certificate of shares held ready for delivery within 2 months in case of physical shares. Then 44 to transfer shares. So obviously you have the right to transfer unless you have to check whether it's freely transferable in nature. Okay. And 94 says to inspect the ROM and register of members and register of debenture holders and get extracts. 119 says to obtain on request, you can get the minutes of the proceedings of the general meetings. And 48, you can apply to the tribunal to have any, in case your variation of rights has been set aside. Okay. And 169, to participate in the removal of directors by passing an ordinary resolution. So these are the list. So if this question is asked, please try to make up with the section numbers also. So that will be helpful. Okay. ஏன்னா இந்த செக்ஷன் நம்பர் போடாம பார்த்தீங்கன்னா கதை எழுதுற மாதிரி இருக்கும். You are not writing stories, you are writing the provisions of the act. Okay. So please try to recall the section numbers. And this is the case particularly um, given by the Supreme Court in LIC of India versus Escort Limited. This it's actually we call this as interpretation. இந்த கேஸ் வந்து கோர்ட்டுக்கு போகும்போது நிறைய விஷயம் டிஸ்கஸ் பண்ணும்போது இதுவும் டிஸ்கஸ் பண்ணியிருப்பாங்க. அதுல என்ன டிஸ்கஸ் பண்ணியிருக்காங்கன்னா, சுப்ரீம் கோர்ட் வந்துட்டு the rights of the shareholder not only from this act, it says it can elect directors and to participate in the management together. For example, nominee director. You can please make a note of it. See what the financial institutions do. They elect a nominee director. Also, they can do it. They can enter the profits of the company in the shape of dividends. To apply to the court for relief in case of oppression. To apply to the court. See, court means now in this case we have a tribunal. See, we have a company, national company, NCLT. We have National Company Law Tribunal. Before we had only Supreme Court. Okay. So that's why the court, and I the tribunal. So for relief in case of mismanagement, for winding up, and to share the surplus in the case of winding. Okay. So that's about shareholders. Let me finish off the last content. It's a very small content. Let me finish it off. So key managerial personnel. Who's a key KMP? Key managerial personnel. Follows from clause 51 of section 2. KMP in relation to a company has been defined as he can be an executive of a company, chief executive officer, CEO, or managing director, or manager of a company secretary, full-time director, CFO, or such other officer. Other such other officer, probably he may be any normal officer, but during this appointment, the company will be saying he will be appointed as KMP. We want to disclose him or give the designation as key management person. So such a person, not more than one level below the directors who is in full-time director. Please make a note. The appointment of the officer, இவர் யாரு கீழே வராங்க full-time director கீழே வராங்க we should not consider as KMP. They will not be considered as KMP. And such other officer as may be prescribed. For example, if I go for I know a few companies where they will define as COO, Chief Operational Officer. Okay, so we have CEO, right? CEO, CMO, COO. We have CMO, Chief Marketing Officer, and we have this one other person, Chief Accounts Officer. அப்படி போட்டு வேண்டியதானே இப்போ வந்து சூப்பரா பண்ணுவாரு இஸ் ஹைலி அசோசியேட் வித் மை கம்பெனி நான் என்ன பண்றது இவருக்கு டெசிக்னேட் ஹை லோன் ஆகும் கேஎம்பியோட டெஃபினேஷன்ல பார்த்தா இதுல வரல இதுல வரல இதுல வரல இதுல வரலாம் அப்ப இதுல நம்மளே போடலாம் போடலாம் தப்பு இல்லை பட் இந்த கண்டிஷன் பார்த்துக்கணும் what is his level compared to the full-time director. After you can designate the role. So you can likewise you can have a chief quality officer. Anything. It's not against you. Not this if this person you are highlighting is equal to the director or one level below that. Okay, see there is a director, full-time director. Check one level and probably this level should be the KMP. இது கீழே போகக்கூடாது பாருங்க நாட் மோர் தென் ஒன் லெவல் பிலோ த டேரக்டர் ஸோ இந்த லெவல் விட்டு இந்த லெவல் வரைக்கும் கேஎம்பிஸ் இருக்கலாம் இதுக்கு ஃபுல்லா கேஎம்பிஸ் இருக்கக்கூடாது ஸோ கேஎம்பிஸ் இங்கோட ப்ராப்ளம் அண்ட் கேஎம்பிஸ் ஆல் த கேஎம்பிஸ் ஆர் நாட் அட் திஸ் லெவல் சி சிஇஓ இஸ் ஈக்குவல் டு டேரக்டர் ஓகே இன்ஃபேக்ட் இஃப் யூ டாக் அபவுட் மேனேஜ்மெண்ட் this director is a full-time director is considered as an employee and CEO and managing director are considered above this level. அப்போ டைரக்டர் full-time director above level by default they will come as KLP. இதோட பில் லெவல்னு வரும்போது ஒன் லெவல் நாட் மோர் தென் ஒன் லெவல் இங்க தான் பார்க்கணும் நாட் மோர் தென் ஒன் லெவல் வியூ ஸோ இங்க தான் பார்க்கணும் ஓகே ஸோ யூ கேன் ப்ளீஸ் மேக் அ நோட் ஆஃப் இட் ஸோ தட்ஸ் அபவுட் திஸ் கண்டென்ட் ஸோ 12.4 alone is pending